talk about what makes for a well-intentioned AI system, what sorts of purposes and safeguards should guide the system, as well as the data governance tools that go into managing the information that trains the system and making sure that the outputs are accurate. AI should have a clear purpose and intent for ethical purposes to begin with. So it should go beyond just efficiency in crunching lots of big data sets to really understanding what are the gaps in employment that the system is trying to fill, and how can you uplift candidates that are not currently being seen by traditional ATS systems. It's especially important to understand different components of laws and regulations that go into diversity outreach and how they differ in the European Union versus in the US. For example, when companies are using an AI system and they have a global presence, it might be worth thinking about how different protected group categories in the US, such as Hispanic or African American, might not translate as directly to European hiring practices. And there are also differences in legal approaches to how non-discrimination is thought of in these different jurisdictions. It's really important for AI systems to be able to prevent and mitigate disparate impact. And disparate impact is a term that really carries over to both US and European jurisdiction. In the EU, it's sometimes referred to as indirect discrimination, and it refers to the practice of using supposedly neutral criteria in hiring that nonetheless has some disadvantaging impact on certain groups more than others. It's important when you are reviewing your AI system in human resources and employment that when you look at the results that it doesn't have direct or indirect discrimination as impacts. And even if certain exemptions for indirect discrimination might apply based on national legislation, for example, some member state legislation has justifications for disparate impact on the basis of genuine job requirements. In the US, it's called the Business Necessity Foundation, that it's not just an exemption that you are applying broadly, but rather that it has a legitimate aim of justifying certain business requirements and that it's necessary and proportionate so that you're not creating more disparate impact than actually is required by the requirements of the job. Some data protection authorities, for example, the French CNIL, has stated that combating employment discrimination is a legitimate goal that should allow for employers to collect sensitive category information about their employees, such as which groups they identify with. So even if there are some conflicts between privacy laws and employment laws, the regulators are moving towards understanding that employers do need to understand the data and understand certain demographic representations in their workforce in order to combat discrimination. AI governance in the European Union really has an anchoring in the Data Protection Directive of 1995, which is a predecessor to the GDPR. So even from a couple decades ago, there was already a right not to be subject to automated decisions produced by computerized systems without human intervention. And it really marked the inception of binding European legislation on automated systems that threatened individual rights. And the policy rationale was really to preserve human dignity and agency against the advancement of machine-led evaluations of personal data. But as the law matured, it began to balance the interests of innovation, especially in AI, with the appropriate safeguards and privacy that enable such sustainable innovation. So instead of completely restricting the uptake of AI, especially AI that can accelerate lots of different industries in the digital marketplace, the GDPR was really designed to modernize AI regulation by having data protection governance tools in place to ensure that AI systems are working off of data that they have a lawful basis to work on, and that there are ways to correct inaccurate information and outdated information in those systems. So the GDPR governs artificial intelligence by adding safeguards to profiling and encouraging human-centered AI. It really pushes forward greater algorithmic accountability in two ways. Number one, by reinforcing the right to an explanation, and by instituting the right to obtain human intervention and to contest automated decisions. If your system is a fully automated one without human review, this is a scenario that would come under the most scrutiny under the GDPR, because a solely automated system has more restrictions and requires additional checks. The first context you should really look at is it a function that is providing a highly repetitive and quantifiable routine task, or are you evaluating someone based on subjective criteria? Because if it is the latter, you should consider having more human intervention to make sure that there is review in the process. And secondly, individuals should have the right to be informed of being subject to algorithmic decision tools by the way of explanation. And the explanation part has different constituent rights that go into it. And number one being the right to access your information that may be serving as input data, and demanding an explanation of how they might have factored into the decision. Article 15 under the GDPR stipulates that data subjects have the right to access the following information, including meaningful information about the logic involved in the algorithm, as well as the significance and the envisaged consequences of such processing. This means that the GDPR is trying to make sure that the lack of transparency won't be an obstacle for individuals to demonstrate discriminatory intent and knowledge in a black box system. And the ethical question on AI and data really stems from the fact that information trains AI. It sets goals and limitations on how much influence AI can have over our lives. And because sometimes information can bake in a mirror of societal prejudices, it's really important to make sure that the AI system is configured in a way that has the checks and balances, and it's not replicating biases. Bias mitigation has a few important factors to consider. Number one, is a protected class overrepresented in a data set that makes the AI think that they're more risky or less qualified to employ? And number two, is your data set limited and non-cross-sectional in a way that there are underrepresented pockets of demographics that excludes them from looking at opportunities or being referred to opportunities? The GDPR explains the different lawful bases for processing information, and the two most relevant ones for private companies are consent from the data subjects as well as legitimate basis. There is also the public interest basis of collecting certain information to see data in a statistical way to make sure that you have enough data to inform decisions that can lead to more diversity in the workplace. Secondly, data quality is really important to make sure that you understand what type of data are you processing from data subjects and why. So this really leads to the question of what is the quantity of the data that you need to ensure that it's accurate and that it's robust. A final checkpoint in data governance is to ensure that consumers and candidates understand the impact of these systems and they are given a understandable explanation of the different factors that go into it. Informational control and informational autonomy is a foundational principle in European data protection law, as well as different areas of fundamental rights in the European Union. To be able to exercise this right would mean that the individual can file a data deletion request if they no longer want to be considered by the AI system. They might be able to correct data that they have noticed was inaccurate in their profile to make sure that the automated assessment or any element of automation isn't inferring inaccurate information about them based on outdated information. Finally, even with these data governance checks and balances, there's always a need for a fail-safe, and the fail-safe always is to have a human in the loop. The new European Commission proposal for AI regulation classifies employment AI as a potentially high-risk category of algorithms that require more assessments, more monitoring, and post-market review to ensure that it's not perpetuating biases. Having explainability and auditability is likely to become a requirement under these new regulations that are being proposed. And it's a really important part of a good data governance strategy because the person deploying these algorithms should be able to understand how decisions are being derived, as well as the person being subject to these algorithms as a candidate. Explainability and auditability of the algorithm ultimately leads to more accountability. In deploying AI systems, it's often difficult to understand what the chain of accountability is if decisions go wrong and how they work in parallel to a manual process that's led purely by humans. Having accountability for an AI system means understanding that the AI vendor or developer has data governance tools in place that are monitoring for the impacts of the algorithm to ensure that it's not increasing adverse impact in the workplace. Accountability also requires an iterative process. It's not enough for the engineers to look at the quality of the data and determine the accuracy from that. Accountability is cross-functional and requires collaboration from engineering, product, solutions, and legal to truly map out the different components of the AI system and monitor the impacts of it in a way that has review in an iterative fashion. Having an ethical AI system really is a continuous task. It doesn't take a checklist approach because data governance tools, AI ethics, security infrastructure, and regulatory engagement really requires a long-term investment in making sure that these AI systems are functioning in a way that can benefit the public interest of helping individuals find the right opportunities. Thank you.